A major loss for Donald Trump at the Supreme Court is good news for democracy, but the bulwark that the judiciary is presenting in the face of Donald Trump's threats has been happening since the beginning of this administration, and it continues even in the face of increasingly threatening rhetoric against judges by the Trump administration. Take one of the most prominent examples, the D.C. District Court Judge James Boasberg, who last week issued a directive ordering the Trump administration to facilitate the return of any of the Venezuelan migrants who are now in third countries as a result of being unlawfully deported last March.
Hello guys, welcome. Adam is here. If you think Trump's legal battles are just about criminal charges and impeachments, you haven't been paying attention to the 14th Amendment. Because multiple judges, actual sitting judges with real legal authority, ruled that Donald Trump engaged in insurrection and should be removed from the ballot.
They're asking you to remove President Trump from the ballot in an election that's occurring in approximately 9 months. They're asking you to tear up all of the ballots across this country on your own initiative. Take that decision away from the American people. And I don't think they spent 1 minute of their 24 hours talking to you about the consequences of that for our country. Not 1 minute. They didn't tell you what that would mean for our country today, this year, and forever into our future. They're asking you to do something that no Senate has ever done. And they're asking you to do it with no evidence.
Not politicians making speeches, not activists shouting from the sidelines. Courts. Judges who reviewed the evidence from January 6th and concluded that Trump's actions disqualified him from ever holding office again under the Constitution. And even though the Supreme Court ultimately saved him, the fact that these rulings happened at all has left Trump shaken in ways that most people don't fully understand.
Trump posted on Truth Social almost a year ago calling Boasberg a, quote, radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama. Trump went on to say, quote, this judge, like many of the crooked judges I am forced to appear before, should be impeached. But as we've come to expect with this administration, Roberts' words don't carry much weight with his fellow Republicans or with Trump. Last month, the Senate Judiciary Committee held a hearing exploring impeachment as a tool for holding what they call rogue judges accountable. This week, Bloomberg reported that senior officials in the Justice Department asked the nation's federal prosecutors to provide examples of, quote, judicial activism that would allow the administration to make impeachment referrals to Congress.
Let's start with what actually happened because the timeline is wild. After January 6th, legal scholars and activists started looking at Section 3 of the 14th Amendment. That's the Civil War-era provision that says anyone who took an oath to support the Constitution and then engaged in insurrection can never hold federal office again. It was written to keep Confederate officials out of government, but the language is broad. It applies to anyone who engages in insurrection, period. So lawsuits started flooding in across the country, arguing that Trump's conduct on January 6th met that definition and that he should be disqualified from appearing on presidential ballots. For a long time, these lawsuits seemed like long shots. Most legal experts thought courts would find some procedural reason to avoid ruling on the merits. But then Colorado's Supreme Court did something nobody expected. On December 19, 2023, the Colorado Supreme Court ruled 4-3 that Donald Trump engaged in insurrection and ordered him removed from the Republican primary ballot. This wasn't some activist lower court making a political statement. This was a state's highest court issuing a 130-page opinion that meticulously analyzed the evidence. They looked at Trump's speech on January 6th. They looked at his tweets. They looked at his refusal to call off the mob. And they concluded that his conduct met the legal definition of insurrection under the 14th Amendment. Therefore, Section 3 applied. He was disqualified. The ruling sent shockwaves through the political world. For a few weeks, Trump was literally off the ballot in Colorado. And then other jurisdictions started following. Maine's Secretary of State, Shenna Bellows, conducted her own review and reached the same conclusion. She determined that Trump engaged in insurrection and ordered him removed from Maine's ballot. A judge in Illinois followed suit, ruling that Trump should be disqualified from the primary ballot there as well. Suddenly, you had three separate jurisdictions with detailed legal findings that Trump had engaged in insurrection against the United States. Think about how devastating this was for Trump. His entire political identity is built on being a winner, on dominating his opponents, on never backing down. And here were courts telling him that he's constitutionally barred from even appearing on ballots, that he's legally an insurrectionist, that the very document he swore to protect and defend now prohibits him from holding office. It was existential. It was the kind of threat that could have ended his political career permanently. Trump's team rushed to the Supreme Court. They made several arguments. They said Section 3 doesn't apply to presidents. They said January 6th wasn't an insurrection. They said Trump didn't personally engage in anything that would trigger disqualification. But their strongest argument was procedural. They said states don't have the power to enforce Section 3 against federal candidates. That authority belongs to Congress alone. And on March 4, 2024, the Supreme Court ruled unanimously, 9-0, that states cannot remove federal candidates from the ballot under Section 3. The reasoning was narrow. The court said that Section 3 is a federal constitutional provision that requires federal enforcement. States can't unilaterally decide who's disqualified for federal office. That power rests with Congress. So Colorado's ruling got reversed, Maine's decision got reversed, Illinois got reversed. Trump was back on every ballot. He went on to win the presidency again. Case closed. Right? Wrong. Because here's what the Supreme Court didn't do. They didn't say Trump was innocent. They didn't say he didn't engage in insurrection. They didn't even address that question. The ruling was entirely procedural. It said even if Trump did engage in insurrection, states still can't remove him on their own. That's Congress's job. So all those lower court findings, the Colorado Supreme Court saying Trump engaged in insurrection, Maine's Secretary of State reaching the same conclusion, the Illinois judge agreeing, none of that got overturned on the merits. It got reversed on procedure. Legally, those findings are still out there. They're still part of the public record. And Trump's opponents can still cite them. And that's exactly what's happening. Democrats and anti-Trump activists constantly reference these rulings. They say, look, multiple courts have found that Trump engaged in insurrection. The only reason he's not disqualified is because the Supreme Court said states can't do it alone. But the facts haven't changed. The evidence hasn't changed. And if Congress wanted to act on Section 3, they could. Of course, Congress hasn't acted. Republicans control the House. They're not about to disqualify their own guy. But the political damage is done because now there's this permanent record of courts saying Trump engaged in insurrection. Let's dig into what these court rulings actually said because the details matter. The Colorado Supreme Court opinion was devastating. The justices went through the evidence systematically. They cited Trump's speech where he told supporters to fight like hell. They cited his tweets attacking Vice President Pence. They cited his hours of inaction while the Capitol was under attack. They addressed every defense Trump's lawyers raised. They explained why January 6th legally qualifies as an insurrection under the 14th Amendment, not just a riot or a protest. They explained why Trump's role was direct enough to trigger disqualification. And they concluded that any other reading of the Constitution would render Section 3 meaningless. Maine's Secretary of State issued a 34-page ruling with similar findings. She reviewed the evidence independently and reached the same conclusion. Trump engaged in insurrection. Section 3 applies. He's disqualified. The Illinois judge followed suit. 3 separate legal authorities, 3 separate evidentiary reviews, all concluding that Trump violated the Constitution in a way that should bar him from office forever. And here's what makes this so damaging for Trump. Courts don't use the word insurrection lightly. That's a serious legal term with a specific meaning. It means taking action to overthrow the government through violence and intimidation. And multiple courts said Trump did exactly that. They said his conduct wasn't just controversial or politically charged. It was insurrectionary. It was the kind of behavior the 14th Amendment was specifically designed to punish. Trump's team knows how dangerous these findings are. That's why they fought the 14th Amendment cases so hard. It wasn't just about staying on the ballot. It was about preventing courts from officially labeling Trump an insurrectionist. Because once that label exists, once it's in court rulings and legal findings, it's impossible to shake. It becomes part of Trump's permanent record. It undermines every defense he tries to make in other cases, and it gives his opponents a powerful talking point that's backed by judicial authority. Think about how this plays out politically. Every time Trump claims January 6th was a peaceful protest, his critics can say, "That's not what the courts found. The Colorado Supreme Court looked at the evidence and said you engaged in insurrection." Every time Trump calls the prosecutions against him a witch hunt, his opponents can say, "Multiple judges have already ruled that your conduct disqualified you from office. The criminal cases are just following the same evidence." The court findings create a factual baseline that Trump can't escape. And this isn't just about rhetoric. These findings have real legal implications in other cases. When Trump faces criminal charges related to January 6th, prosecutors can point to the 14th Amendment rulings and say, "Courts have already determined that Trump's conduct meets the legal definition of insurrection." That's persuasive authority. It doesn't decide the criminal cases, but it makes prosecutors' jobs easier. It creates momentum. It establishes that reasonable judges have already concluded Trump's actions were insurrectionary. The Supreme Court's unanimous ruling also matters in ways that aren't immediately obvious. The fact that all 9 justices agreed that states can't enforce Section 3 on their own suggests the court wanted to avoid a chaotic patchwork of state-by-state disqualifications. But by ruling so narrowly, they left the door open for Congress to act. And that's Trump's nightmare scenario. If Democrats ever win control of both houses of Congress, they could pass legislation enforcing Section 3 against Trump. They could hold hearings, present evidence, and vote to disqualify him from future office. The Supreme Court has already said that's constitutional. So Trump's political future depends entirely on maintaining Republican congressional majorities. Let's talk about what this means for the midterms and beyond. The 2026 elections aren't just about control of Congress. They're about whether Trump remains eligible for office. If Democrats take the House and hold the Senate, or even just take the House with a narrow majority, they could start Section 3 proceedings. They could subpoena witnesses. They could review evidence. They could vote to declare Trump disqualified under the 14th Amendment, and based on the Supreme Court's ruling, that action would likely be constitutional. Trump would have to challenge it in court, and he might lose. That's why Trump is so desperate to keep Republican majorities. That's why he's campaigning harder than ever for GOP candidates. Because he knows that if Democrats get control, his political career could be over through a mechanism he can't control. Not through impeachment, which requires a Senate conviction. Not through criminal prosecution, which requires a jury verdict. Through a simple majority vote in Congress declaring him disqualified under the Constitution. The irony is that Trump survived the 14th Amendment challenge in the courts only to face an even bigger threat in Congress. The Supreme Court punted the question to the legislative branch, and if the legislative branch ever flips to Democratic control, Trump's in serious trouble. The lower court findings give Democrats a ready-made evidentiary record. They can cite the Colorado ruling, the Maine ruling, the Illinois ruling as proof that Trump engaged in insurrection. They can hold hearings and build a case without starting from scratch. The work is already done. For voters, this creates a strange dynamic. Trump is president now. He won the election, he's in power, but his long-term eligibility is uncertain. He could be disqualified from running again before the next election cycle even starts. That uncertainty affects everything. It affects how allies treat him. It affects how opponents plan their strategies. It affects how Trump himself governs, knowing that his political future might be decided by congressional votes rather than voters. The 14th Amendment battle also reveals something important about Trump's vulnerabilities. His opponents aren't just fighting him through elections and impeachments. They're using the Constitution itself as a weapon. They're finding provisions that were written 150 years ago and applying them to modern circumstances. And sometimes, like in Colorado and Maine, they succeed. They get courts to agree that Trump's actions violate fundamental constitutional principles. Even when those rulings get reversed on procedural grounds, the underlying findings remain. The stain remains. Trump's legal team understood this intuitively. They fought the 14th Amendment cases with everything they had, not just because of the immediate ballot access issue, but because of the long-term damage these rulings could cause. And they were right to be worried. Because now, every time Trump's name appears in a headline about January 6th, there's a footnote about courts finding him an insurrectionist. Every time he claims vindication from the Supreme Court, his opponents note that the court never addressed the merits. Every time he tries to move past the events of that day, the court rulings pull him back. So where does this go from here? The 14th Amendment question isn't settled. It's just shifted from the courts to Congress. And Congress hasn't acted yet, but the potential for action is always there. If Democrats win big in the midterms, if they take control of both chambers, the pressure to disqualify Trump will be immense. His opponents will argue that leaving an insurrectionist eligible for office mocks the Constitution and the rule of law. They'll point to the court findings as evidence. They'll hold hearings and build a record, and Trump will have to fight yet another battle for his political survival. For now, Trump is safe. Republicans control the House. They're not going to disqualify their own president, but the 2026 elections could change everything, and Trump knows it. That's why he's so focused on maintaining congressional majorities. That's why he's so aggressive in campaigning against Democrats. Because his political future literally depends on it. The courts gave him a temporary reprieve, but they also handed his opponents a roadmap. And if Democrats ever get the votes, they'll follow that roadmap straight to disqualification. The bottom line is simple. Multiple courts ruled that Trump engaged in insurrection and should be removed from the ballot. The Supreme Court reversed those rulings on procedural grounds, not on the merits. So the factual findings remain. Trump is legally an insurrectionist according to multiple judicial authorities. And if Congress ever flips to Democratic control, those findings could become the basis for his permanent disqualification from office. Trump survived the 14th Amendment challenge, but he didn't escape it. The sword is still hanging over his head, and only Republican majorities are keeping it from falling.